Good morning, ma'am. My name is Diego Cantas from 1E2 at nandito po ako para ibahagi yung aking mga natutunan sa subject na criminal justice system. Una is the criminal justice system. When we say criminal justice system, ito yung system na maraming parts at nag-interact sila sa isa't isa. At ito rin yung machinery na ginagamit para mag-prevent at makontrol ang crime. Sunod is the word justice. When we say justice, ito yung social norm na nagpo-provide ng guidance sa mga tao. So next is the nature and function of policing. According to Robert Peel, the police are the public and the public are the police. So next is the power and function of PNP. So we have enforce all law, maintain peace and order, investigate and prevent crime, search and seizure, and detain arrested person not beyond what the prescribed by law. And also, they are the one who will issue a license for the possession of firearms and explosive in accordance with the law. And they are the one who will supervise and control the training and operations of security agencies. And also, the last one is they will perform such duties and exercise all other functions as may be provided by the law. So next is the evolution of Philippine policing. So there is the pre-Spanish era. Cabecera de Barangay was the head or the leader of the group. And the first organized police was the Carabineros de Seguridad Pública. In police patrol, patrol is the proactive measure of policing, and also patrol is the backbone of the organization, and it is the eyes and ears wherein the police plans and actions are based upon. In Philippine Constabulary Act number 225, in this PC personnel were Filipinos placed under the supervision of American officers. In Insular Constabulary Act number 175, it is an act providing for the organization and government of the Insular Constabulary, whose function is to provide peace, keeping orders, and enforce law, headed by General Henry Allen. Then there are two types of justice. First is the substantive justice at procedural justice. So pag sinabing substantive justice, ito yung concern siya sa kung paano mag-allocate, mag-distribute, and protect the substantive values of society. When we say procedural justice, concern naman siya how law was administered, mechanisms or process are used. Sa School of Thoughts about Justice naman, nandito yung positive law theory. So when we say positive law theory, it is the justice is served as by adhering the law. So when we say law, it is the instrument for justice, and it is the major input of criminal justice system, and also it is the method of social control. When we say statutory law, it is a legislated law, or it is law made by legislatures. So pag sinabi naman nating case law, it is a law that made by justices in cases decided in the appellate courts or especially in Supreme Court. So there are two types of law, the civil law and the criminal law. So when we say civil law, it is have something to do with the contracts, wills, inheritance, marriage, divorce, or even in the private injuries that we call torts. When we say criminal law, it is a branch or division of law which defines crimes, threats on their natures, and provides punishments. Next is the institutional approach in criminal justice system. So we have the historical approach, the legalistic approach, the socio-behavioral approach, the what we call the world order approach, the operational reality approach, the reform approach, and the organizational approach. So when we say historical approach, it reveals the origin of the current legal thinking. Then when we say legalistic approach, it examines the role of legal theory in criminal justice. And when we say socio-behavioral approach, it defines the contribution of the psychology and the social science in criminal justice. So when we say world order approach, it adopts the holistic views based on the religious, the economic, and the socio-cultural concept of the world. So in operational reality approach, the utopian theory attempts to consider the criminal justice system as it is pragmatic in practice. So when we say reform approach, it attempts to adjust and reform the components of criminal justice system. And when we say organizational approach, the criminal justice procedure evaluate them in consideration with the governmental standards. In ancient Babylon, the first organized police in that time is way back in 200 BC in ancient Babylon. So next is the elements of criminal law. There is the function and the sanction. So first, the function, it is the preservation of the social order in the society. When we say sanction, it is referred as the satisfaction to the public. So next is the major components or pillars of criminal justice system and its function. So we have the law enforcement, the prosecution, the courts, the correctional, and the community. So when we say law enforcement, it consists of Philippine National Police, and they focus on the prevention and control of crime. So when we say prosecution, the primary concern of this is the investigation of grievances or the complaints. So in court, given the prosecution has to prove that there is a strong evidence, we need to note that if there is any doubt that the accused committed that crime, he need to be acquitted. So in correctional, sila yung nagki-take over ng mga accused, and they can apply probation to a non-institutional or institutional custodial treatment or rehabilitation. So sa community naman, ang ginagawa dito ay nagpa-participate sila sa mga law enforcement activities, and nagpa-participate din sila sa promotion of peace and also in prevention of crime. So next is the stage of criminal justice process. So we have the arrest, the charging, the adjudication stage, the sentencing, and the correction. So in arrest, they are taking a person in a custody in order that he may be bound to answer. So next is the charging. In charging, the police output in the form of arrested or in book suspect becomes input on the stage. The prosecution will decide if the suspect will try for the commission of crime, and they will decide whether the case will proceed to the next stage or it will be dismissed. So next is the adjudication stage. Input triggering in the case before the court, the formal charges are filed in the accused. At first, the arraigned or the reading of charges against the accused. The accused can be plead guilty or not guilty in the charges, and the trial will start. So in sentencing, the judge will consider all the circumstances of the case, and it is his duty to apply the provision of the law in rendering the punishment or the sentence against the accused. So in correction, convicted person serving of the sentence imposed, the offender will be reformed and rehabilitated. So yun po ma'am. That's all po. Maraming salamat po sa pagtuturo niyo sa amin. Ah, ingat po lagi. God bless.